State versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
The video opens with a narrator amused and baffled at the same time. Because today's episode showcases a rare cosmic event, a Karen and a sovereign citizen wrapped into one single defendant, Ashley Clark. As the judge calls the case, her attorney calmly informs the court that she intends to stipulate to the probation violations, meaning she planned to admit and accept the agreed-upon sentence. But before anyone can breathe, Ashley decides to derail the entire proceeding by firing her attorney on the spot. The narrator highlights that this is the classic, "I got this myself" moment. Famous last words uttered right before someone self-destructs in front of a judge. The scene is already chaotic, and we all know the train wreck is just beginning.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
The judge is clearly trying to help her avoid disaster. But Ashley, like every self-appointed legal mastermind, believes she's completely ready. He reminds her that self-representation means following rules of evidence, court procedure, and legal standards just like any attorney. She confidently responds, "Yes, sir," without the faintest idea what that actually entails. The judge gives her every chance to reconsider, checking whether anyone threatened her or promised her anything, and verifying that she understood the form she signed. Each "yes, sir" she gives is filled with misguided confidence, foreshadowing the disaster headed straight at her face.
I call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample for Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
When the judge asks whether she wants to stipulate or contest the violations, she proudly announces she wants a contested hearing. This is the equivalent of a toddler challenging LeBron James to a dunk contest. The attorney she just fired had already negotiated a deal to protect her, and she threw it away to perform sovereign citizen freestyle poetry in court. The judge, unfazed, calls for the probation officer, the only witness needed. Meanwhile, the narrator is quietly enjoying the meltdown brewing under Ashley's delusion of control.
Your Honor, I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Morsinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve.
The court briefly pauses to retrieve the probation officer, and the prosecutor says he has no opening statement. Ashley also declines to give one, which is unsurprising considering she doesn't understand the basic structure of a hearing. The narrator cracks up at her confidence, because we all know confidence without competence is just ego dressed in clown makeup. It's clear she didn't fire her attorney because she had a strategy. She fired him because she thought sovereign citizen buzzwords magically win court cases.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in.
The first witness, probation officer Hollis, immediately establishes every violation with brutal clarity. He states she tested positive for methamphetamine and signed an admission confirming she used meth. He then explained she was ordered to report again on June 2nd but failed to show up, and that she hasn't reported since. On top of that, he confirmed she was arrested for new charges and never reported the new law enforcement contact to his office. It's a clean sweep for the prosecution. There's no ambiguity, no procedural issue, no wiggle room. It's a legal beatdown.
Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
When the judge asks whether she has questions for the probation officer, she simply says no. The narrator rightfully loses it because sovereign citizens always know how to fire a lawyer, but none of them know what to do next. She didn't challenge the drug test, didn't deny the arrest, didn't question the reporting failure. She just sat there silently, having challenged a hearing she wasn't prepared for. The prosecution has the only evidence, and she doesn't even try to counter it. The judge generously gives her the chance to present evidence on her behalf. She responds with a sovereign citizen script that has nothing to do with probation law. She claims there is no evidence of personal or subject matter jurisdiction, calls the state a fictitious plaintiff, insists no injured man or woman is present, and throws IRS tax code into the conversation like it's some kind of UNO reverse card. It's legal gibberish, a meaningless stew of misunderstood buzzwords, but she delivers it proudly, believing she just blew the judge's mind. The prosecutor's closing is short and devastating. He explains the violations clearly and emphasizes that this is a misdemeanor probation, meaning she gets no sanctions ladder, or multiple chances like felony cases sometimes provide. She simply broke nearly every rule she agreed to. Then Ashley gives her closing argument, which is another avalanche of sovereign citizen nonsense. She repeats the jurisdiction lines, claims the state of cannot testify, and randomly mentions she is acting as surety for the named principal and wants to be compliant with IRS excise tax laws. It's delusion at its finest. The judge calmly dissects the entire situation with surgical precision. He lists each violation she committed: confirmed meth use, failure to report, failure to complete treatment, failure to report new charges. He explains that she violated the terms in a substantial way and that probation would be pointless because she clearly isn't capable of complying. Then he drops the final hammer: probation revoked, underlying jail sentence imposed, and she is taken into custody immediately. It's a textbook example of how not to represent yourself. As deputies move in to arrest her, she unleashes her final sovereign citizen superpower, shouting imaginary fee schedules. She claims she is owed $1,200 for every minute she's in jail, as if the judge is going to Venmo her from the bench. The narrator ends with a comedic reminder that hiring a public defender is always smarter than trying to be your own conspiracy theory lawyer. The outro wraps up with jokes, commentary, and a final roast. Representing yourself and doing nothing is the fastest way to secure free housing in jail.